Hey there, I'm Mr. Terry and I'm a high school history teacher. Welcome back to another History Teacher X video. All right, just recently I commented on the LegalEagle video that was very critical of the Supreme Court decision on immunity for presidents. And be sure to check that out because I think that'll give some context for what is going on here, because this next video is titled, "The Supreme Court Destroyed the Government While You Weren't Looking." So with all the hubbub going around about that Supreme Court decision, we got all kinds of turmoil going on in the presidential race right now. It looks like Devin and the LegalEagle crew have got some more to talk about. Now, this original video is going to be linked down below. Definitely check that out. By the way, we're currently having a flag design contest where there's going to be prizes for the winners. And if that sounds like something interesting to you, I'll put some info down in the description. All right, let's check this video out. All right, so the tone of that last video was very, very negative, course, about the presidential immunity case, and most of the response that you see on media and just by individuals on social media is, again, very negative, because in that video, and I talked about it too, you know, the worst case scenario that could come out of that could be something very, very bad. And I was hoping to hear some arguments to say why it should be actually be seen more as a positive thing. And a lot of you guys put a lot of comments down below, again, mostly negative out of there. Now with this video, just by the title of it, "The Supreme Court Destroyed the Government While You Weren't Looking," we definitely see another negative spin because it's saying while we weren't looking. So with all of us, again, all distracted, I guess, by that last Supreme Court ruling, and then the chaos that's going on with the presidential race right now, and then we got wars going on, this can be some time, a time where things can kind of sneak through, legislation or whatever. People talk about distractions all the time when it comes to government. So let's see what we got here.
And the Supreme Court has destroyed the entire federal government. Well, that's only slight hyperbole. Maybe just the entire administrative state. Now, you might have heard of Chevron Deference. Well, the Supreme Court just killed it, and that's a big deal. It's a huge deal.
Okay, that's what we're talking about this video.
Generally, you have to be in the know to understand. But it would be like if the Supreme Court just said all briefs must be filed in Latin. Maybe it won't affect you on an everyday basis, but it really screws up the judicial system, and it's going to be a pain in the ass for lawyers and judges going forward. Now,
okay, so we talk about the Chevron thing. I have just heard about that too, and again, it's been one of those things that I've seen as very negative, as it's kind of snowballed in with the presidential immunity thing. So, but this might be one of those things. We'll see if I can add historical context, but if you, again, are much more into law and studying law, give me your feedback down below.
To understand this massive decision, you need a quick primer on administrative law. Here's 3 things you need to know. First, Congress passes laws, and generally courts interpret those laws because sometimes those laws are ambiguous.
Yep. So we got 2 branches.
A lot of those laws establish or empower federal agencies because the government is big and does a lot of stuff. And finally, a ton of what those agencies do is highly technical or scientific. So sometimes Congress...
By the way, that's a key thing that we generally enjoy as a republic, the fact that powers are delegated, and that you don't have to, whether you're a citizen or even necessarily a politician, have to be just like completely educated on every single thing. You have people that become experts in certain areas and you take their advice and all that. I think that's a good thing. When we go to the doctor's office, we want to listen to the doctors, right? And they give us feedback. And of course, inevitably we can make our own decisions on things, but like we have people that are experts in certain things, and that's important for a society to even function.
Intentionally leaves laws ambiguous so those agencies can do their jobs.
Yep.
And Chevron Deference is all about what happens when a federal agency deals with an ambiguous law. And chaos lawyer Liz Dye has more on this catastrophe.
Thanks, Devin.
Who's this?
The Supreme Court has executed its biggest power grab in decades, and it's all thanks to a tiny little fish. Yes, the nation's high court issued a joint holding in 2 cases known as Loper Bright Enterprises versus Gina Raimondo, the Secretary of the Department of Commerce, and Relentless Inc., v. Department of Commerce, both of which involved regulation of herring fishing in ocean waters. The ruling, which overturns a long-standing principle known as Chevron Deference, paves the way for courts to rewrite administrative regulations more or less at will. So now, judges can overrule those pesky experts on stuff like what constitutes a distinct population segment under the Endangered Species Act? When does an alpha amino acid polymer qualify as a biological product under the Public Health Services Act? Or how much airplane...
I can see already where they're going with this, right? They're trying to understand the judges are not going to be experts on all this stuff that has to do with chemistry and biology and all that. So we've we've given more power away from the experts.
Okay. Noise reduction is sufficient to substantially restore the natural quiet of the Grand Canyon under the 1987 Overflights Act. Okay. Those three examples come from the dissent authored by Justice Elena Kagan and joined by her fellow liberal justices Sonia Sotomayor and Ketanji Brown Jackson.
This is the voting lines you also saw with the immunity case. So these, again, judges dissenting, heard all about their arguments in that last video about immunity. So looks like we're going to get that too. But, a lot of people try to, talk about the judicial system as trying to be apolitical, and that's never, ever really been the case. It's not like they're running as part of a political party, but the whole process of nominating judges, because that's what you do, right? And Supreme Court justices, of course, are nominated by the president, is they're going to, always bring in a judge that is going to be more closely affiliated with their political beliefs and be more likely to approve of legislation that they support. So it is a very political thing. And again, when you have, say, like the last presidency under President Trump, we're able to nominate 3 justices. That's unheard of. That is a huge swing that can, heavily tip pretty much every Supreme Court case, because they largely vote on the same lines a lot.
As Kagan notes, the majority's holding in Loper Bright allows courts
to substitute
their judgment for that of scientists and policy wonks who certainly know more about the topic than federal judges. And that represents a massive shift of power away from the executive branch to the judiciary. It all started in 1977 when Congress amended the Clean Air Act to force polluters to submit to a permitting process known as new source review every time they wanted to construct a new stationary source of pollution. Under President Jimmy Carter, the Environmental Protection Agency interpreted the law to require permits for every new smokestack.
That's by the way, with Jimmy Carter, if you don't know much about him, his legacy has probably been one on environmentalism more than probably any president really up to that point, for sure. And one of his big legacies. So I was gonna say that, looking at the 70s, that definitely looks like a Carter era thing.
So to be clear, Congress did its job and enacted a law, and then the executive branch implemented it through rules and regulations, which is its job. But when President Reagan was elected in 1980, his EPA took a different approach. It decided that new source review was only triggered if the improvement increased the amount of pollution in the bubble of the entire project. So a factory could install a new, highly polluting modification without a permit so long as its overall emissions didn't go up, defeating the purpose of the Clean Air Act amendments, which were intended to force new construction that reduced pollution overall.
This is where you see what I was talking about, judges and the judicial system being aligned with kind of political decisions or political platforms. So one of the things that has, been a big part of more like neoconservative political platforms is deregulation of industry and things like that, so that there could be less cost, for these businesses to be able to operate, which is going to be better for the for prices and make private industry more, profitable. Then you have, other opinions that says the government should actually get involved, because, what is going to keep these businesses from doing any kind of, protectionism on their own, especially when that often, again, leads to lower profit values. So this is what we're talking about. We actually have Supreme Court decisions that will align with certain political beliefs. Deregulation being a very important one for conservatives as well as, the Republican Party in general.
In 1981, the National Resources Defense Council sued the EPA in federal court in D.C. That case was captioned NRDC versus Gorsuch because the nominal defendant was EPA Administrator Ann M. Gorsuch, the mother of future Supreme Court Justice Neil Gorsuch. In an opinion authored by future Supreme Court Justice Ruth Bader Ginsburg, the D.C. Circuit invalidated the rule change because it conflicted with both precedent and the stated purpose of the statute, which was to reduce pollution. The Chevron Corporation, an oil behemoth whose interest did not lie in cleaning up the environment, intervened, and by the time the case landed at the Supreme Court, it had been rechristened Chevron USA versus NRDC. Writing for a unanimous court, Justice John Paul Stevens reversed the D.C. Circuit, articulating what was known for the past 40 years as the Chevron Doctrine, or Chevron Deference. Under Chevron, courts conducted a three-part test when faced with a challenge to an executive agency's interpretation of federal law. First, the courts examined the statute authorizing the agency action to see if its language was ambiguous. If there was ambiguity, it was presumed that the agency was authorized to make rules to fill any gap left implicitly or explicitly by Congress. That gap constituted an express delegation of authority to the agency to elucidate a specific provision of the statute by regulation. Second, the court assessed whether the challenged agency interpretation was reasonable. And if so, courts would defer to that interpretation, hence the name Chevron Deference. Only if the agency—
This is why I have justices in general, because even that has ambiguous things, like saying if it's reasonable, and like those things are, largely subjective. Now, if you haven't noticed, usually I pin a comment to every video, kind of like an overarching question for you guys to think about and to give, I think, really good feedback on. And we'll see if this is the one I go with here, but you can get kind of started thinking about it. With things going on with the Supreme Court, and you see what the Supreme Court does, and a lot of it we're going to judge by just in the recent weeks. How do you feel about the power of the Supreme Court? Do you think it is something that has too much power? Does it have just the right amount of power? Is it not powerful enough? What do you guys think about that? Let me know down below. And again, if you see me with a pinned comment there, reply to that one.
Agency's interpretation was unreasonable, would courts rewrite agency regulations so as to make them comply with the law? Justice Stevens noted that judges are not experts in the field and are not part of either political branch of the government. When a challenge to an agency construction of a statutory provision, fairly conceptualized, really centers on the wisdom of the agency's position rather than whether it is a reasonable choice within a gap left open by Congress, the challenge must fail. In Chevron versus NRDC, this meant that the EPA was free to water down the standards of the Clean Air Act and let corporations continue to pollute the air. But in practice, this gave presidential agencies broad power to interpret federal law and enact regulations that reflected the administration's political priorities. So, for example—
the EPA, by the way, Environmental Protection Agency, is something that's going to change the way that they interpret things, and the way that they regulate is going to change a lot depending on, the president, because he can appoint, leaders there. So it's something that's back and forth, just like a Supreme Court can be, or I guess every political institution that we have, Congress and Senate, goes back and forth. This is one of those things when you got somebody that is you don't elect the leader, like us as citizens, we don't elect who's going to be the leader of the Environmental Protection Agency. It's not one of those positions. Of course, same with the Supreme Court. It's indirectly done.
The Trump and Biden administrations took radically different approaches to whether Title IX's prohibition on discrimination because of sex required sports teams to include or exclude transgender athletes. Since the Chevron decision came down in 1984, conservatives took control of the judiciary,
outside of
solidifying a 6-seat majority on the Supreme Court and seating the federal bench with loads of federal judges selected from the conservative movement specifically to oppose liberal policies. Meanwhile, as the country became ever more sharply divided, Congress has become ever less effective, passing fewer and fewer laws. With Congress functionally has become ever less effective. Meanwhile,
by the way, Justice Thomas, man, this guy's come under fire too so much because people find out about people that are in his inner circle and have given him gifts or whatever it is here. So he's hanging out with a real estate developer. There's just like with Congress, you have lobbying. These people can interact with other people. They can take money, I guess, from people, and you're supposed to disclose it and all that stuff. But a lot of people say with justices that is maybe even more dangerous than just like a politician, just because like a Supreme Court justice has so much power, right? They really do. They do have quite a bit of power because the Supreme Court is very small and it's a lifetime position.
Specifically to oppose liberal policy.
Okay, what was this one?
Meanwhile, as the country became ever more sharply divided, Congress has become ever less effective, passing fewer.
Okay, so Capitol Center 2023 led to fewest laws in decades. Bills enacted by congressional session. So done like 4 or something like that, they said. And usually they do a lot more decisions. A lot of that can be difficult when there isn't huge numbers that favor a certain political party. You know, things that actually are going to require people to kind of cross the aisle. But this is something too that a lot of people criticize about governments is they don't do enough. And you can see here by this stat, they're saying it's like insanely low.
Fewer and fewer laws.
This past
With Congress functionally broken, presidents have come to rely more and more on executive action and rulemaking. And so overturning Chevron became one of the main goals of the conservative movement,
it's fake,
allowing them to more easily challenge executive actions by Democratic administrations without the annoying obligation to defer to an agency's interpretation of laws. In 2020, Justice Thomas wrote that Chevron compels judges to abdicate the judicial power without constitutional sanction and gives federal agencies unconstitutional power. In 2022, Justice Gorsuch warned that the doctrine poses a serious threat to some of our most fundamental commitments as judges and courts and deserves a tombstone no one can miss. And so it was clear that Chevron, like Roe v. Wade, was doomed. Although it wasn't obvious that Chevron would be toppled by a tiny little fish.
Now, obviously, if you're going to challenge the entire administrative state, you're going to need a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you or a loved one has suffered from mesothelioma, if you've been in a car crash or suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or just about anything else, we can represent you or help find you the right attorney, because it's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below.
In 1976, Congress enacted the Magnuson-Stevens Fishery Conservation and Management Act, so named for Democratic Senator Warren Magnuson and Republican Senator Ted Stevens. The law established 8 regional fishery management councils dedicated to protecting commercial fishing stocks. The councils were vested with various powers, including authority to require that one or more observers be carried on board a vessel for the purpose of collecting data necessary for the conservation and management of the fishery. And it was that power enumerated in 16 U.S.C. Section 1853b, which wound up taking out the edifice that held up administrative law in this country for 40 years, because the law did not specify how those observers were to be funded. Or, to be more precise, it did, but not super clearly. Section 1855 contained a general implementing clause authorizing the Secretary of the Department of Commerce to promulgate such regulations as may be necessary to discharge such responsibility or to carry out any other provision of the Act. And Section 1858G allowed the councils to punish any vessel owner for failing to pay for the observer's services, which would strongly imply that Congress intended the councils to be able to charge boats for the observers. And that was certainly the position taken by Donald Trump's Secretary of Commerce, Wilbur Ross. But it was not the position taken by a company called Loper Bright Enterprises, which sued the Department of Commerce in February of 2020, calling the regulation an unlawful mandate by the federal government that requires herring fishermen along the eastern seaboard of the United States to carry National Oceanic and Atmospheric Administration contractors, called at-sea monitors, on their vessels during fishing trips, and moreover to pay out of pocket for costs associated with allowing these government contractors to monitor their fishing activity.
Again, doesn't this all come back to economics? Isn't that what it's all about? Different economic theory and role, different opinions about the role of government, where those that believe the government is and has to be the safety net against the exploitation of companies. But then you have, the opinion that for economies to function, that government, that businesses know what they're doing, are going to make the good decisions and regulate themselves, but that it's just, the economy comes first. That deregulation is at the heart of a good economy.
2 weeks later, a similar lawsuit was filed by a commercial fishing company under the caption Relentless Inc. v. Ross. Now here's a fun tip. When you're trying to figure out why a lawsuit was filed, skip to the signature block and Google the lawyers who put their names on it. The Loper Bright case was brought by Ryan Mulvey and Eric Bolender, 2 lawyers from the group Americans for Prosperity, which was set up by billionaire brothers Charles and David Koch to combat climate legislation, unions, and minimum wage laws, and generally fight all progressive policies.
The paper trail, you have that. You should be doing the same thing with all things like polls and studies if it's a legitimate study, it's a legitimate poll, it's going to have sources. You're going to be able to follow that to see who is conducting these things. Are these places that have, very clearly stated agendas? Now, I understand there's bias in everything, but not all things are as openly biased as others, and you can track that stuff. And you're saying there with laws and could doing the same thing that we should be doing with polls and all data.
And the Relentless case was brought by lawyers from the New Civil Liberties Alliance, another group funded by the Koch brothers to attack government regulations, which is a pretty good indication that the fish here was just a big old red herring.
But Koch brothers, some of the wealthiest people on the planet. If you didn't know.
These cases were always torpedoes aimed straight at the Chevron doctrine, and they scored a direct hit. The plaintiffs lost at the trial courts in D.C. and Rhode Island, and then lost again at the D.C. and First Circuits. And by the time they wound up at the Supreme Court, the only question being considered was whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. In short, the justices had given up the red herring and were aiming straight for the iceberg.
Iceberg, right ahead!
Thank you. Chief Justice Roberts wrote the opinion for the court's 6 conservatives, framing the reversal of Chevron as the righteous repudiation of a grievous error. In his telling, Chevron ushered in a 4-decade period of judicial laziness where courts abdicated their responsibilities under the Constitution. He said, when faced with a statutory ambiguity, the ambiguity is not a delegation to anybody, and a court is not somehow relieved of its obligation to independently interpret the statute. He quoted Chief Justice John Marshall from 1803 saying in Marbury v. Madison that it is in fact—
I love the hearkening back to 200 years ago and that kind of stuff. And a lot of people, they look at that stuff as like religious doctrine almost when it comes to, early years of decisions and things like that. Like literally here, they're bringing up Alexander Hamilton and bringing up Federalist Papers and stuff like that. Now, Marbury versus Madison, of course, is a very important foundational decision for our country, but
emphatically the province.
Always interesting when you see citations of things that just go so far back,
of the Judicial Department to say what the law is. He quoted the Federalist Papers, noting that the framers also envisioned that the final interpretation of the laws would be the proper and peculiar province of the court. He also quoted the Administrative Procedure Act, which was originally passed in 1946 and specifies that courts, not agencies, will decide all relevant questions of law. He referenced various respected commentators who endorsed his position that only the court can interpret a law and that the court owes respect, but not deference, to the executive branch agencies charged with actually carrying it out.
This argument that he's making, right, someone supportive of this, is doing a pretty good job, I gotta say, of, supporting this and saying that this is kind of stuff that was foundational from the original framers of our Constitution, because, that's what these justices are supposed to do, is interpret laws, that exist. And since the Constitution is such a holy relic in the founding of our country, that hearkening back to those original opinions are usually going to be met with positivity. Because it's not very popular to, really criticize a lot of things that come from like the original Constitution. There's a lot, but you got to understand how some people and many people are so. The only thing I can look at is almost looking at the Constitution like it's a religious document. These are actually really strong arguments I feel like he's making, especially to those that are going to think the way that he does.
And he cited various attempts by his own court to water down the holding in the past 20 years as evidence that the Chevron test imposes a dizzying breakdance on the courts and is wholly unworkable.
She's doing the mockery tone.
He even sneered at the—
We call that tone when we talk about in class. When we're analyzing anything, we any kind of documentation or anything, tone. When you're hearing somebody interpret something, what's their tone? Because you can learn a lot about that. So that would be an example of tone, how she's reading and interpreting this decision.
A quorum of 6 justices who decided Chevron since Justices Marshall, Rehnquist, and O'Connor recused themselves. It's an odd way to describe a unanimous opinion, particularly since Roberts himself is speaking for just 6 justices. And it's especially odd in a holding where Justice Gorsuch's own mother was the defendant in the case being overturned. The majority's opinion boils down to this. In every case where a statute is ambiguous, there must be a best reading of the law, and courts are obligated to use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity themselves rather than letting the experts, tasked by Congress and the voters, fill in the blanks. Yeah. But as Justice Kagan's dissent for the court's 3 liberals points out, sometimes statutes are just sloppily drafted, and there is no best answer for a blank Congress forgot to fill in. And if there is a best answer, it's probably not going to be arrived at by courts applying general principles of law. In fact, it may not be a question of law at all. The Chief Justice yada 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 is that Congress expects courts to handle technical statutory questions. But that's a particularly ironic thing to say on the same day when Justice Gorsuch dropped an opinion in which he confused nitrogen oxide, a greenhouse gas, with nitrous oxide, better known as laughing gas. Because there isn't a balls and strikes answer to every technical question of administrative procedure. And Justice Elena Kagan made this point by highlighting a bunch of cases decided on the basis of Chevron Deference, like Teva Pharmaceuticals versus the FDA, which turns on the question of when does an alpha amino acid polymer qualify as a protein, or what does distinct mean when you're talking about various populations of endangered squirrels. That was the issue in Northwest Ecosystem Alliance versus U.S. Fish and Wildlife Services.
I wanted to find a way. I haven't been able to find a way to sneak this into the video and make a better segue for what's going on right now. I feel like one of the legacies from our coronavirus pandemic, everything that came with that, from vaccines and mandates and all those things, is the experts were corrupted or whatever it is a political posture. And I feel like one of the legacies that is definitely coming out of the pandemic is a distrust for experts, because when politics can be tied to experts, like you have these agencies that are approved by Congress and they're appointed by Congress and those sort of things, that it's impossible to separate the politics from those agencies and their decisions. They're not neutral type of things. And I mean, that's true. Like, everyone has biases and all that stuff. But I think people have come away with saying that pretty much every expert, everything that's seen as an expert, and I'm not just talking about those that are federally regulated, but even outside of that, just in the private world, I feel like there's a legacy of distrust now. Respect for experts is on the decrease. And maybe I'm speaking hyperbolically, maybe I'm crazy to think that, but I feel like that's definitely a thing. I can tell you as a teacher seeing it in education. In education, there's been an anti-education movement that has been going on that is also, I've seen, wrapped up, even though it's existed, but wrapped up in the pandemic and how that was treated, and how as a something that is connected to legislation and politics like that part of a forced agenda of some kind. So I feel like that, not to call myself an expert, but being somebody that teaches, I think teachers have influence kind of similar to that with maybe medical professionals or whatever it is. And now they're tying it to environmental issues and all this, that there's an anti-expert, I don't want to call it an anti-intellectual movement, but very close to that.
Or what does a geographic area mean when you're talking about Medicare reimbursement rates? See Bellevue Hospital Center v. Levitt. I'm a lawyer and a reasonably smart person, and I don't know the answer to those questions. And neither did the federal judges who decided those cases, because there wasn't one best answer for the court to divine by scrutinizing the statute and applying principles of law. Congress writes laws, which are pretty general, and leaves it to the executive to carry them out, which is why the judges deferred to the federal agencies that administer the Food, Drug, and Cosmetics Act and the Endangered Species Act and the Medicare Act to define those terms.
I think laws are also purposely written ambiguously. I think it creates a wiggle room for people that are not 100% sure to be able to find something in there that they can maybe support. I think that's very intentional. Sometimes when things are too specific, then you find more objectivity to it. People will find something to nitpick. It holds up laws and keeps things from being passed.
But according to Chief Justice Roberts, it's actually the court's job to grab a pen and mark up a statute anytime the law is unclear. He wrote, "It therefore makes no sense to speak of a permissible interpretation that is not the one the court, after applying all relevant interpretive tools, concludes is best. In the business of statutory interpretation, if it is not the best, it is not permissible."
That line is hard to draw in some cases. I would say not in most cases, and make sure that this is the question that you, the judge, are supposed to be deciding rather than someone else.
And it's certainly not what he said about the foundational doctrine of stare decisis, or at least it's not what he used to say.
Yeah. So that's one thing we find a lot. So when Supreme Court justices are nominated, they go under some real scrutiny from Congress as they're seeing these nominees, and they grill them on stuff and basically just want to vet them in saying, okay, what do you think about this issue, this issue, this issue, this issue, this issue? How would you vote on it? And it's happened repeatedly where people have changed their opinions on that. One of the ones that most recently has been accused of is those justices nominated by Trump, like people that were, people in Congress that were very much wanting to see a protection of like Roe v. Wade, for example, and saying, could that be overturned? Like, would you vote to overturn that? And and they were saying, no, that's kind of like, it's a super precedent. They call it a super precedent, something that's like, it's so ingrained that it's just, you can't even touch it. So they said it was a super precedent, but then you saw what happened when it was overturned, putting it to a state's issue. And for them, it's like, hey, I'm not saying we're not like putting in something that says it's legal or illegal, just saying we're pushing it to a state. But all of those people that were grilling them, all those congressmen that were grilling them were expecting and assumed, and it seemed like the way that they said it, that they would not rule on it in any form.
Stare decisis is a Latin term meaning to stand by things already decided. In law, it means that precedent is binding on subsequent courts. And once an issue has been ruled on, that is the law of the land. And while the Supreme Court can overturn precedent, there has always been a strong institutional taboo against doing it because it makes the justices seem like partisans who rule based on their own policy preferences. But precedent is also important because we all rely on knowing what the law is. And if that law is constantly changing, then it can cause major civic and social instability.
Please disperse. Nothing to see here, please.
But Donald Trump's election prompted a major sea change. He was able to name 3 justices decisively swinging the Supreme Court to the right, at which point conservatives got a whole lot less concerned about stare decisis. So during their confirmation hearings, Justices Kavanaugh and Gorsuch mumbled a little bit about Roe v. Wade being settled law before immediately voting to overturn it in the Dobbs case. Since then, senators have switched to asking judicial nominees whether Brown v. Board of Education, the seminal school desegregation case, is settled law, with alarming results.
Do you believe that Brown versus Board of Education was correctly decided?
Okay, hold on. I want to see her answer. This is one of those things that is supposed to be such a no-brainer that anything but a very clear answer. And in this situation, we got Brown versus Board of Education. We got segregation in schools.
I don't mean to be coy, but I think I get into a difficult area when I start commenting on Supreme Court decisions, which are correctly decided and which I may disagree with.
Yikes. There is just no argument that Chevron was anything other than settled law. As Justice Kagan noted in her dissent, the doctrine has been applied in thousands of judicial decisions. It has become a part of the warp and woof of modern government, supporting regulatory efforts of all kinds, to name a few: keeping air and water clean, food and drugs safe, and financial markets honest. Overturning it requires total disregard for stare decisis and more than a wee smidge of judicial arrogance. Luckily, Justice Gorsuch was happy to oblige. In a 34-page concurrence, he praised the majority for its brave act of judicial humility in conceding that its own precedent was wrongly decided. Then he celebrated the tombstone on Chevron no one can miss, calling back to his own earlier writing, as all truly humble jurists do. Along the way, he rubbished the idea of stare decisis generally, noting that in the 18th century, common law judges did not, broadly speaking, afford overwhelming weight to any, quote, single precedent. And in ye olde England, a judge's decision might bind the parties to the case at hand, but none of that meant the judge had the power to make a law properly so called for society at large. For that, only the king and parliament can do.
I mean, they're the common law stuff and all that. That goes back to like pre-United States constitutional things. So here they're bringing up stuff from before the American Revolution even took place. You got stuff from 1713. But yeah, common law. That has to deal with like law when we were under English occupation. All that stuff changed when the United States became independent and set up their own system. Chief
Justice wasn't willing to go quite that far, but that's why he spent so much time talking about Marbury v. Madison and pre-Chevron practice, while claiming that Chevron was totally unworkable and forced judges to breakdance.
Dude, he's a good breakdancer.
Because if you say, well, this law was working fine for 4 decades, but we didn't like it, and now we have the votes to overturn it, so we did, it sounds kind of bad. Or as Justice Kagan put it, this court has avoided deferring under Chevron since 2016 because it has been preparing to overrule Chevron since around that time. That kind of self-help on the way to reversing precedent has become almost routine at this court. Stop applying a decision where one should, throw some gratuitous criticisms into a couple opinions, issue a few separate writings questioning the decision's premises, give the whole process a few years, and voila, you have a justification for overruling the decision. Ouch. But Justice Kagan wasn't done pointing out the hypocrisy. She observed that the majority cannot destroy one doctrine of judicial humility without making a laughingstock of the second. That is, the majority was so excited to ditch the Chevron doctrine and substitute their own opinions for those of government experts that it trampled the doctrine of stare decisis and showed their whole herring to the world. She added that if opinions had titles, a good candidate for today's would be hubris squared. In his holding, the Chief Justice went out of his way to minimize the chaos that this ruling will unleash. He offered assurances that all the previous decisions made based on Chevron doctrine are still good law, and the holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis, despite our change in interpretive methodology. But it cannot be overstated what an earthquake this will be for administrative law. If the EPA wants to regulate industry to cut pollution, or the FDA wants to ban harmful additives, or the Labor Department wants to set standards for overtime rules, or the Federal Reserve wants to limit credit card swipe fees, all those things will be challenged. In fact, that last one is not a hypothetical. In a case called Corner Post Inc. v. Federal Reserve Board of Governors, decided on the last day of the term, the Supreme Court effectively abolished the statute of limitations for challenges to an administrative regulation. Previously, a rule had to be challenged within 6 years of its enactment. Now, a party has 6 years from when it began being harmed to sue, meaning that a bank can set up shop tomorrow and challenge a rule that has been in place for decades because its harm is brand new. And as Vox's Ian Mill has
statute of limitations is potentially going to be totally redefined that way. Seems like something like this, if they're saying, the courts are going to decide on a lot more issues, that's going to put a lot of strain on courts. They're going to be doing a lot more of this stuff. And obviously our criticism is that shifting this stuff to, like the Supreme Court, which is becoming more and more clearly and unapologetically political as time goes on. Don't like that. It's becoming not only less democratic, but also moving away from the people that have more informed knowledge on these type of things, and then handing it over to people that know nothing about it.
Warns,
it's like, then why have any of these agencies at all? I mean, maybe that's kind of the thesis here they're getting to, is these organizations are going to have no power whatsoever.
And ultimately, the Supreme Court responsible for resolving thousands of low-stakes policy questions, which often cannot be resolved simply by reading the law's naked text. The justices, in other words, can look forward to missing their children's basketball games, skipping out on date nights with their spouses, and not really doing much of anything at all, besides deciding the crushing weight of cases that are about to land on their desks. Yeah, boo-hoo. A blog post by the Union of Concerned Scientists predicts that the end of Chevron will introduce a new level of difficulty to the regulatory process. Agencies like the EPA will need to try to anticipate every potential legal challenge alleging statutory ambiguity and prepare comprehensive justifications that can withstand unbounded judicial scrutiny.
This is going to obviously be impacted more when you have like the EPA with a leadership appointed by a certain president, and does that president, obviously he's going to appoint people that align with their opinions. Is that going to reflect what the current status of the Supreme Court is? So if you have like a conservative president and a conservative Supreme Court, then you have a conservative EPA, then there's probably going to be no issue at all. It's when there's a difference. You have a Democrat, but you have like a conservative or a Democratic president and a Democratic more leaning EPA leadership, but then a conservative Supreme Court. So that's where this stuff, it will be debated upon.
This could slow down the implementation of new regulations, as agencies might take more time to ensure their rules can survive such legal challenges. Worse, agencies may decide not to even try, all of which is very bad for people who like clean air and drinkable water and overtime pay.
There'll be less radical
lenders
changes,
can charge consumers and
or it could be the opposite, though. Like the changes they make, again, depending on the political alignment of the leadership and the Supreme Court, could pass very radical things or stop anything. It could go either way.
Without too much rat hair in them, and a million other tiny decisions which were previously made by experts and will now be subject to challenge by industry lawyers responsible to shareholders and special interests, and not answerable to voters.
See, that's where this all is coming back to. And because we live in a time period, and I'm still believing this, that people believe more and more that everything is politicized. Everything is. Anything that even comes close to touching the government is going to be politicized. Okay. So again, EPA, Congress, Supreme Court, everything. And people have no faith in that political bias, if you want to call it that, supersedes whatever expert knowledge you have. And that sucks, if that happens then, because then all of a sudden experts of anything don't matter.
Side, Justice Gorsuch finally got that tombstone, so I guess it was worth it.
It's rough.
Now, that was a great explanation, but I want to emphasize more about this 1-2 punch of Loper Bright and Corner Post. Because frankly, Corner Post might be an even bigger deal than Loper Bright and the end of Chevron Deference. Because it's possible the end of Chevron Deference wouldn't have that big of an effect on its own. In part because bad faith jurists have been claiming to apply Chevron Deference for years, but basically just ignoring it and coming to outcome-oriented decisions. Many have said that Chevron has been dead for a while. But now it's truly dead, and judges will be the last and only word on ambiguous statutes. And with Corner Post, truly, no federal regulation will ever be settled. Corner Post has effectively done away with the statute of limitations when it comes to federal regulations. And that's going to lead to an absolute deluge of litigation. I would not want to be a federal judge right now. They were already overworked and underpaid, and now they're going to be interpreting and reinterpreting regulations all the time.
I don't know, though. I mean, a big criticism of justices is that they are politicians. They get into it. They're activist judges. You ever hear that? You hear that all the time. Everyone's an activist judge. They're going in to pursue an agenda rather than be some kind of nonpartisan, unbiased interpreter. And nobody believes that anymore.
But of course, it's not going to be all courts. As we've already seen, there are a few judges, especially in the middle of nowhere, Texas, that love nothing more than to overturn current laws. So you're going to see thousands of newly minted corporations incorporated in Amarillo, Texas, challenging a regulation and then going before that company's preferred judge, just to overrule federal regulations. And additionally, because those judges are not subject matter experts, you're going to get a lot of wacky decisions. Not necessarily smaller government, but definitely weirder, less predictable government. We're going to get a whole weird patchwork of dueling interpretations and rules with inconsistencies between the states and circuits, and we're going to see a lot of junk science and cherry-picked history to get to outcome-oriented decisions.
So it's impossible to separate this Chevron ruling from the one that we just had on presidential immunity. And it seems like with the two videos now I've watched this week, that their overall takeaway from these, if you want to combine them, is that these court cases have, first off, given presidents way more power, and then also it gives the court system more power. Now, my question coming back to you guys is this. What do you think about that? One of the things I was talking about in the immunity ruling was, what problem does this fix historically? And then we have this current ruling. What problem is this fixing? Then looking at from this other perspective, which is the best case and worst case scenarios of these two decisions. In the immunity one, my kind of conclusion is that the worst case scenario is way worse than what could be the best of the best case scenario from that. Now, from this one, I'm kind of getting similar vibes that the worst case scenario is, again, way bigger than maybe the best case scenario. All right, guys, with that, thanks for hanging out with me. See you next time. Bye.